Please the court, counsel. I'm Mark Sessoms. I was trial counsel for Henry Driggers, and I'm representing him obviously on this appeal as well. We have not only filed an initial brief, we filed a motion for appellate fees. And the issues in this case were twofold: whether the trial court abused its discretion in denying the modification that was requested in light of the unrebutted testimony that my client had suffered a severe downward reduction in his income, and also whether the trial court abused its discretion in granting contempt in the face of that unrebutted evidence. These parties were divorced in 2003, and when we had the trial in this case, my client was 57 years of age. He's in the air conditioning business. He has a 1/3 interest, along with his sons, in a business in Fort Meade, which, along with many other small businesses, is suffering from the economic malaise of the recession. And he filed a motion for modification. His original order was $1,250 a month in terms of alimony, and by the time of the trial, he was making $1,154 a month. After paying his alimony, his deficit would have been $1,329 a month. His testimony was unrebutted that he suffered a 40% loss of income in the business as a whole. He paid his alimony. At the time of the divorce, his income was $40,000 a year. That appears on page 50 of the record. And so he paid his alimony for 2003, 4, 5, 6, 7, 8, even though his income by then had reduced by 50%. He was only making $21,389 by that point in time. In 2009, he paid his alimony even though his income had dropped to $3,083. In 2010, his income was $1,452, and he paid all but $600 of his alimony. In 2011, his income was $9,358 for the year, and he paid only $3,800. So counsel is correct that by the time of the trial, the arrearage was $25,000, which is a very significant arrearage. However, he had no ability to pay it because he had
If I understand, Mr. Sessoms, the company is paying his condo fees or mortgage.
Yeah, the company was paying his expenses. However, that's a red herring. Obviously, companies are entitled to pay whatever they choose to pay. They just have to show it as a distribution.
They paid his truck.
I'm sorry?
They paid his truck.
They paid his expenses.
He had 6 employees. He, his 2 sons, and I guess there was a total of 6 or 8 employees total.
I don't remember the number of employees. I know his sons are there, and I know he's there, and I know they have other employees, but I don't remember the number. But all the expenses were accounted for. Okay. Simply because a company pays an expense doesn't eliminate it as an expense, and it shows up as income. So the testimony was he had accounted for all of that in terms of what he was reflecting as his income.
The company has accounted for the distributions.
I'm sorry?
The company has accounted for its distributions.
Correct. It shows up on a K-1. It appears on your 1040 tax return as a shareholder distribution. So it doesn't really matter which pocket it comes out of. The total income was as reflected on his financial affidavit. He was showing those expenses that the company was admittedly paying for him. He could have done it a different way, but it's form without substance. He could have taken a check from the company, which he testified, I'm not taking a check because the company's paying my expenses. So if he takes the check, then he has W-2 income, and then he pays additional taxes on it.
Could the court have reasonably concluded that Mr. Driggers wasn't making sufficient efforts to grow the business or to find new employment? I mean, there may be conflicting testimony, but he spends upwards to 2 months at a hunting lodge.
The only evidence of some inappropriate lifestyle is this hunting lease. However, the hunting lease is for 6 people. Counsel argues about the total bill, but there's 5 people that are involved in that lease. His 2 sons and him and 2 other people.
Well, I'm not focusing on the cost of it. Let's assume it's $6,000 and we split it.
$6,000 total. It's like $1,100 for his, $1,200.
But I guess the testimony suggests that I've got a fellow who claims poverty, but he's off at the hunting lodge for 2+ months a year.
But there's no testimony about what he would have made during that period of time. There's nothing that supports that somehow he's hamstrung himself. I mean, he's got absolutely no ability to pay. Had he been in Fort Meade and remember, there is testimony that in the past, a power plant job came to them because of taking people to it. So there's some translation to producing income.
Yeah, but he took no one in 2012.
I'm acknowledging that.
And in prior years, he couldn't remember taking more than 2 people.
Wished he hadn't gone and hunted so much. Wish the testimony was different. But it is what it is. But I don't think it takes us anywhere because there's no correlation. There's no evidence that takes us to any different spot. So if he's only making $1,100, and had he been in Fort Meade, we can surmise he might have made a little bit more, but not materially different. Likewise, you could also conclude reasonably that things are so bad that he figures, gosh, I might as well just go to Georgia and stay with my girlfriend and hunt a little bit. So I don't know that really takes us anywhere. And that's the only...
I might reduce my overhead to business by getting rid of unnecessary employees and
it might.
keep the work to myself.
It might. So I acknowledge that it's there. That's the one fact. But the court doesn't seize on that. The court instead says, very interestingly, there's not a lot of evidence proving he can pay out of Southeast refrigeration. It's right there in the record. So the totality of the unrebutted evidence is his testimony of, I can't go be a field mechanic for somebody else. I'm not making any money. I've exhausted my assets. He's got a truck with 225,000 miles on it, some shotguns or a rifle, whatever the guns are, a old tractor that he uses up there to clear trails, a four-wheeler, which is worth very little. I mean, he's got virtually nothing and no income. And there's no evidence that was offered by Mr. Baker or Mr. Baker's client to the contrary to rebut that he's not making any money. I think the court has to, at the very minimum, say, you know, we're going to award $1 a year, and sir, you know, I'm going to hold you responsible and say you can't go hunting more than X next year. And I want you to report how many days you go. Something along those lines, we could deal with the issue that you raised, Judge LaRose. But I think, given the unrebutted evidence and the horrific weight of it, the court just abuses discretion by doing nothing, by denying the modification and holding this man in contempt and making him sell the minimal assets that he had to come up with the $3,000 purge, especially when you consider the former wife's circumstances. Now, she's had health problems. However, the record's clear. She says, no doctors tell me I can't work. I'm making more than I made at the time of the divorce. She's not reflecting all of her income on her financial affidavit. She's taking care of grandchildren and paying their expenses. You know, no problem with it, but it shows an increase in her financial circumstances.
But that's counterbalanced by what I understand to be some pretty high remaining health care bills.
If you look at her net assets, they've gone up, I think, from $40,000 to $75,000. So, and I'm accounting for the debt in that. Right. So she got 2 pieces of property. She got $50,000 when she sold the house that the parties occupied together. She's got a retirement that's worth $60,000. My gentleman has nothing. And I think this is part of the, you know, the groundswell that you saw for Senate.
That retirement income and the property she sold, that relates back to what she received in the original dissolution?
I can't correlate the two because I didn't represent Mr. Driggers then, but I know she has the retirement, I assume, from State Farm where she works. And so that's obviously a steady job. I know she got the $50,000. I think she used it for her most current house and potentially this other property. They're related transactions. Her and her mother and her son have kind of moved things around, but she owns 2 pieces of property.
The record doesn't tell us how that traces back, if at all.
Yeah.
Distribution.
Right, I can't tell you. But I know her net assets have gone up from $40,000 to $75,000. I know she's got, I know she shows a deficit on her financial affidavit, but her income has gone up. I know the court erred when it said there's no change in her income because it's higher, and she didn't show all of her income. Admittedly, there's about $200 a month that she didn't show in terms of an increase. The court just ignored that. The court ignored the online income. And I think many times you get into these modification things, and what happens is the courts just say, we're not going to change anything. And you know, this is a policy issue. I think that we need some guidance from the court about these type of cases, that you can't just blithely ignore, you know, weighty evidence. And I think this is in part why you had the groundswell for Senate Bill 718 last year that passed the legislature and ultimately was vetoed by the governor, is these kind of cases where people are just left in these horrific economic circumstances where they just can't do anything. And so I would submit that there was clear error on the record. And I don't know how much time I used, but I'd like to reserve 5 minutes if there's no other questions right now.
Very good.
Thank you.
Thank you. Good morning. My name is Steve Baker. I'm an attorney in Winter Haven, Florida, practicing since 1976. And if I look at you a little peculiarly, it's because I'm totally blind. And by the same token, if you all roll your eyes or any of that, I won't see it, so it won't work. I think this case is primarily factually driven, and I think the issue is, was there an abuse of discretion? When we filed this case, I believe it was in December of 11, Mr. Driggers had not made a payment since May. I think he was 7 months behind. When we finally got before the judge, he was $25,000 behind. If you'll notice, the judge only awarded $3,000 on the purge. That's not a lot of money to go through all the effort my client went through up to that point. I think of course, I view my conclusions are entirely different than Mark's.
Well, Mr. Baker,
yes.
help me out.
Sure, Your Honor.
We're looking at a situation where the wife financially is a little better off than she was at the time of the divorce. And the business, Mr. Driggers' business is going down the tubes. Where's he going to get the money to pay?
Judge,
Or why, what is it that we can put our finger on and say, oh, the judge got this right?
well, Judge, number one, he paid $3,600 his attorney from funds of the Southeast Refrigeration. So I think he's probably been a little less than candid in telling us his ability to pay or the extent of money he can get from Southeast Refrigeration. I think it's
everything is properly accounted for in terms of distributions from the company. I mean, as I understand, their books are properly kept. They show any distributions made to Mr. Driggers, and I wasn't aware that his tax returns were challenged as being incorrect.
No, we haven't challenged his tax returns as being incorrect because we're not, it just wouldn't be financially worthwhile hiring a forensic. It costs as much as the man owes to hire a forensic accountant to go back through all that stuff. But may it please the court, I think it's a matter of lifestyle, and Mr. Driggers, according to his testimony, has made no effort to find new employment. What he is, according to his testimony, what he is doing is he is holding on to this business which he claims is just barely making it, waiting for the tide to turn. While he's doing that, he's taking off up to 60 days. He says 60 days per year to go hunting. I would submit to the court that if somebody in business took off 60 days a year, they're going to have a terrible time making a success of their business. They need to devote their full time and attention to their business and maybe a little less time and attention to hunting. But that's a lifestyle change that he's voluntarily chosen that. He wants to go hunting. He's not putting that time into his business. He's not out looking for a new job or new career that'll pay him what he was making prior to the Depression.
Right. Should we infer that Judge Spoto was making a conclusion that he was underemployed? He doesn't say that, but.
He doesn't say that, but I think that could certainly be inferred from his decision. Of course, I don't know what was in Judge Spato's head, but I think the judge saw this and said, well, the man he's made a voluntary lifestyle change, and he's put that ahead of his obligation to pay his ex-wife. And then, as I stated, Judge Spato only awarded $3,000 as a purge in the case, so it wasn't any great. I think he should have done more than that, but that wasn't in itself any great incentive to get the gentleman out looking for more work or better job, or spending less time hunting and more time on the job.
Is it correct that the former husband's evidence supported a conclusion that his income and his ability to pay was reduced after taking into account the income he receives plus the expenses paid by the company? And am I understanding that was his evidence? My income's reduced, but yes, expenses have been paid by the company, but the net is a reduction.
That's right. I believe that's correct, Your Honor.
And there was no, let me phrase it this way, was there any evidence to establish that in fact he could have and should have earned more, or was it basically argument as to what the facts showed?
Well, there was certainly no direct testimony that he could have gone to work for Company B and made $50,000 a year. There's no testimony like that. My impression of the evidence was that the evidence pointed out that he had made a voluntary lifestyle change, and I think the judge could infer from that reduced his income.
And the lifestyle change being the trips to the hunting lodge.
Right, the trips to the hunting lodge. And also he made a
lifestyle change, Mr. Baker. He was doing that even during the marriage.
Well, I don't think so. Not like, is he from Central Florida? Yes. Was he hunting? Probably. But not like we heard about here in the testimony. And I think that
was there evidence that he could have earned more income by reducing the number of employees that he had and doing the work himself?
There was no specific.
Candidly, one of the things that concerns me about this case is what appears to be a lack of evidence. And you've got a court who seems to be drawing conclusions based on the hunting trips, and yet if the work isn't there, I'm not certain it's unreasonable to say, well, I'm just going to go ahead and enjoy the free time I have right now. The economy is bad, and so I can't earn more. And the flip side of that coin is, well, he might have been able to earn more had he done the work himself and gotten rid of other employees. And yet there's no real evidence to address those alternatives.
Right, but I think when we go into the case, we go in with a presumption in favor of my client, a presumption he has the ability to pay, and he's got to prove that he doesn't. And that's probably a close point, but I feel like A, he didn't overcome that presumption. B, based on the testimony, the judge could certainly conclude that this was his lifestyle change. This was his voluntary on his part, and if indeed the business was not making any money, it was his choice to stay with the business. Maybe that was a good choice or bad choice if business picks up.
Well, the court's conclusions are the former husband has willfully and intentionally failed to pay, and then the court finds that there has been no material change in the circumstances justifying a reduction.
Yeah.
But the only factual support, or the only significant factual support, seems to be the husband has voluntarily elected to spend from several weeks to 60 days per year hunting. I mean, do you agree that that is the factual basis that the court is relying on?
No, I also think the fact that if he's indeed continuing to work for a company that's not making any money, I think that's basically a voluntary choice on his part.
But wouldn't there have to be some evidence to show that it was unreasonable to expect this business might turn around as the economy improves, or alternatively, some evidence that would show if he left this business, he could be making double the income at ABC Air Conditioning?
Well, I think that under ideal circumstances, it would be good to have that type of evidence, but I think the court can see he's working for a company that says it's basically not paying him more than $1,100. Previously, he'd been making up to $50,000. I think the court can conclude that he would have the ability to get a better paying job. There's no evidence of any health problems that prevented him from doing so.
But there's no history of Mr. Driggers avoiding his alimony payments until this recent period, because for the first three or so years, he paid all the alimony that was due.
Yes, that's true. Yes, Your Honor. That's right. So, any other questions for me? Well, in conclusion, it's our position that, one, he didn't overcome the presumption. Two, that his reduction of income was voluntary. It was a lifestyle change on his part. And that's basically it. Thank you very much.
Thank you very much, counsel.
I think Mr. Baker was quite candid when he said that essentially he was waiting for the tide to turn, that his tax returns, there's no dispute, his tax returns show what they show and that they're accurate. I think when you have that kind of acknowledgement, the facts are compelling, and it becomes not simply a fact case as counsel would indicate, but this court's case in Boone versus Boone is analogous. In that particular case, the former wife had a surplus. I know the former wife here shows a deficit, however, her circumstances have gone up. And the former husband had a deficit of $130 before paying any alimony, almost exactly what we're dealing with on his side of the equation. And the court reversed and remanded for an amended award to $1 a year. There are also cases that we've cited, Zabias and Hahn out of the 4th DCA, where the court said it was an abuse of discretion and entered an order terminating the former husband's obligation. So I would submit there's ample authority, legal authority, which I would note is not even responded to in the responsive brief, that would support the elimination of this obligation.
How about a remand for more factual findings?
The court certainly can do that. I think, when you have uncontested evidence, that substantial competent evidence, for instance, he testified, I'm too old, it's on page 47 of the transcript, I'm too old to go work and be a field mechanic for someone else. So then the burden, we're talking about burden of proof, the burden then shifts to the former wife, because he sustained his burden. The burden then shifts to her to show vocationally or from another owner, et cetera, that they would hire him and place him in a job.
The challenge we have, and I guess it probably comes up in a lot of cases, there ain't a lot of money to go around. We can't hire an accountant.
No
we
doubt.
Can't hire a vocational expert.
I agree. I would have loved to have a CPA testify in this particular case. I understand and appreciate Mr. Baker's concern about hiring a forensic accountant, but we do this for a living.
No, but it's a problem for both sides.
Both sides. We know how to read tax returns after you've done this for a period of time. You know how to read bank statements. You know how to create your own exhibits, etc. You know how to pick up the phone and call a former client, or you get the name of another business and say, what would they earn? So we know how to do these things ad hocly without experts on the cheap, especially in smaller counties. There's no evidence. So to remand for other specific findings, I would submit to, that it just creates an additional expense. The evidence there, my client sustained it. He's too old to have another field mechanic job. His income from the business is reduced substantially. He's not making any money, and there's no competing evidence. So I think the court should, at the minimum, should reverse and remand for $1 a year, and or should, as I think more appropriate, just simply terminate the obligation. I think it's been acknowledged that there's no evidence on the other side. The only thing that was spoken about was he paid Mark Sessom's $3,600. However, he paid it on a credit card, Southeastern Refrigerator's credit card, but that's right there in the transcript on page 28, and it's, so it's not cash that's been paid out. It's on, it's admittedly his expense, and somehow it's going to have to get paid, or somebody's going to pursue it, but there's just no evidence to support it.
Was there evidence presented as to what the other employees of the business were being paid?
No, not specifically. It was not. We produced all the records, and I don't remember specifically what the sons were being paid, but there was no challenge to what they were being paid. Is it?
Theoretically, the court could have said, I find the former husband lacking in credibility. I find he has been hunting for 60 days or up to 60 days a year. I find that he has been paying employee number 1 or employee number 2 this much money, which he could have earned himself had he been on site and working. And then this would be much more easily affirmed.
Well, the court could have done a number of things. I don't know how the court could have not found him credible in the face of the tax returns when there's no indication that they're inaccurate. But supposing that there was some basis.
Well, the court could have found a lack of credibility in terms of business is down, and so I was able to take advantage of hunting.
If sons are making $200,000 a year, or
$50,000,
50 in this case, it would have changed the circumstances. Correct. Both sons making 50 and dad's making this, then you got an issue. Or if somehow it's not getting reported as a distribution, you have an issue. But here, all these records are offered up. There is no challenge, because Mr. Baker was pointedly asked that. There's no challenge about discovery. There's no challenge about veracity. There's no challenge about those comparisons. We had a trial. There's no evidence on the other side. And the court it's not just a blank slate. The court specifically said there's not a lot of evidence proving he can pay out of Southeastern Roofing, and only ordered a purge that he could pay by liquidating his remaining assets, largely. So obviously the court's sensitive to this, but just says, I'm not going to do it because he's hunting a little more than I would like, I think is what we can ultimately surmise is what happened. But the court had other available remedies to it, and that hunting, as you very pointedly noted, is equivocal. It's ambiguous. What does that mean? We don't know. But the record evidence is he's not making enough money even to pay his own bills, and he doesn't have any ability to pay the alimony. So I think I'd ask the court just to deal with that expeditiously and reverse, and hopefully for $1 award or terminating it, and awarding fees as well. Thank you.
Thank you, Mr. Sessoms. We are going to take a 10-minute recess. After the recess, we're going to hear the case of Holden versus Gu or Ju. I'm not certain how it's pronounced. And then we have a oral argument by telephone, which will be the last case on the docket. So we are in recess for 10 minutes.